Hey everyone, today we have chosen the topic Basic Structure Doctrine under the Constitutional Law. What is basic structure? Basic structure is not something that you can describe in a definition, or there is no straitjacket formula to understand the basic structure concept. It's something that has evolved throughout a period of time by the courts. The Supreme Court, in a number of cases, has helped us to understand what basic structure is. For an example, there is a building. You can renovate the building, you can bring changes to the building, you can modify the building, but you cannot dig in so deep that you affect the foundation of the building. Similar is the case with constitution. You can modify the constitution by amendments, you can bring changes to the constitution, but you cannot change the constitution to such an extent that the basic essence of the constitution is taken away. You cannot modify the constitution so much to an extent that the purpose for which the constitution was created is affected. You cannot touch the soul of the constitution. This is what basic structure is. Now, this basic structure doctrine has a timeline that we need to understand. For this, we need to understand two articles, Article 13 and Article 368. Article 13 says that any law that is made in derogation with the fundamental rights is void. That means anything that is in derogation of the fundamental rights, that is Part 3 of the Constitution, will be void. And Article 368 says that it talks about amendment, that Parliament can amend the Constitution, right? So what happened was, let's begin with the timeline. First Amendment. First Amendment came in year 1951. What happened in the First Amendment? Three things: Article 31A, Article 31B, and Ninth Schedule. We all know what Ninth Schedule is, because anything that's put in the Ninth Schedule cannot be touched upon. It's beyond the scope of judicial review. What Article 31A is, it basically gave Parliament the power to take over the estates and corporations in public interests. It could modify the rights of the people or extinguish the rights of the people related to those estates and corporations. What Article 31B did was that it could put laws to the ninth schedule, and they were given protection from the judicial review, right? So these three things were challenged in the case of Shankari Prasad versus Union of India. Now what the court said, that see, Article 13 is for ordinary laws, but what amendment is special law. So Article 13 cannot be applied to amendments, because amendment is a special law and Article 13 deals with ordinary laws, so it could not be applied. So what was done? First Amendment was held to be valid in the eyes of law. Now what happened was, after the First Amendment came, 17th Amendment also came in the year 1964. What happened in the 17th Amendment? More provisions were added to the ninth schedule. Now this was the First Amendment and the 17th Amendment. They both were challenged in the case of Sajjan Singh versus State of Rajasthan in the year 1964. But what happened? The Shankari Prasad case was still held to be valid, and both these amendments also were held to be valid in the eyes of law. After this, Golaknath case came. Golaknath versus State of Punjab in the year 1967. Now in this case, both the earlier decisions, basically the Shankari Prasad and the Sajjan Singh one, they were overruled. And the court said that the Parliament cannot abridge the fundamental rights, except the limitations that have been given along with the fundamental rights. But the Parliament cannot abridge the fundamental rights, and therefore Article 13 will apply to Constitution amendments as well. Now this changed and nullified the earlier amendments that were done by the Parliament, and because of that another amendment was brought in, which was the 24th Amendment in the year 1971. What 24th Amendment did? It added two things: clause 4 to Article 13 and clause 3 to Article 368. What Article 13 clause 4 said, that nothing in this article shall apply to any amendment of the Constitution made under this article. And Article 368 clause 3 said that nothing in Article 313 shall apply to any amendment made under this article. Now what it did, it gave unlimited power of amendment to the parliament, which is basically an unlimited arbitrary power which was taken by the government themselves by making such amendments. Then another amendment came, 25th Amendment in the year 1972, through which Article 31C was added. Now, Article 31C had two parts. The first part said that anything which is done as for the purpose of DPSPs, for the directive principles of state policy, if such things are in derogation of Article 14, 19 or 31, you cannot say that such acts or laws that are made by the parliament, they are void just because they are against the Article 14, 19 and 31. And the second part was that it was taking away the power of judicial review of the courts. It said that no law containing a declaration of giving effect to such policy shall be questioned in any court of law. Now what happened, 24th Amendment along with the 25th Amendment, 29th Amendment, they were all challenged in the most important landmark case in the history of law, which is the Keshwanand Bharti case. Keshwanand Bharti case is considered to be the landmark judgment for a lot of things, but here we will study it in the context of basic structure. Keshwanand Bharti versus State of Kerala in the year 1973. The judgment date is very important to remember. It's 24th April 1973. Now, this case gave us the basic structure doctrine, and the court said you cannot touch the soul of the constitution. You cannot amend the constitution to an extent that you're taking away the very essence, the very purpose for which the constitution was made, right? So it said that you can bring changes to the constitution, and for this matter, the Article 31C's first part was held to be valid in the eyes of law. That okay, you can modify the constitution, you can change the constitution, but the second part, which was taking away the power of judicial review, the court held it to be unconstitutional and against the basic structure. The court said that judicial review, the power of courts to analyze the laws, is a basic structure principle, and you cannot amend it so that you take it away from the courts. You are altering the basic structure, and this is where it was decided that judicial review is part of basic structure, and it was held in the case of Keshwanand Bharti. Now what happened, we understand now that okay, basic structure doctrine was given to us in the Keshwanand Bharti case. This is not where it ends, this is where it starts, and the doctrine keeps on evolving with the different case laws and with time. Now what happened after the Keshwanand Bharti case, we all know there was an electoral malpractice case which is famously known as Indira Gandhi versus Raj Narayan. Now in Raj Narayan versus state of Uttar Pradesh in 1975, the Allahabad High Court held the Prime Minister, that is Indira Gandhi, she was held to be guilty of electoral malpractice. And so, while the appeal was pending in the Supreme Court related to that matter, the government brought in the 39th Amendment in the year 1975. And what it did with the 39th Amendment, it added Article 329A, which basically took away the power of the Supreme Court to deal with election disputes in relation to the Prime Minister, to the President, to the Governor, to the Vice President. Now, in the case of Indira Gandhi versus Raj Narayan in 1975, when the Supreme Court heard the case, it said that it is completely against the basic structure. You cannot take away the power of the court to deal with such matter, and it said, Matthew Justice said, that this clause destroyed the essential democratic feature of the Constitution, which is the resolution of an election dispute by ascertaining the adjudicative facts and applying the relevant law. You cannot take away that power from the court. So Article 329A was held to be unconstitutional. Now what happened? 42nd Amendment came. We all know 42nd Amendment is known as the mini constitution, and it happened in the year 1976. It added two things, Article 368 clause 4, Article 368 clause 5, which basically again amended the powers of the parliament, and it gave unlimited amending powers to the parliament, and article 31C was also amended again. Now in Minerva Mills versus Union of India in the year 1980, both of these clauses that were added to article 368, the 4 and 5, they were held to be unconstitutional because it was taking away judicial review, which is basic structure, right? So and this case evolved the basic structure doctrine. So what happened, once decided that okay, basic structure is a safe boundary, is a boundary, you cannot go beyond that boundary, you cannot touch the essence of the constitution, you change it, you modify it, you make it so that you are helping with the public welfare, but you cannot change the constitution so much that you're taking away its essence. So these are some cases that are related to the basic structure doctrine, and a timeline from the first amendment till the 42nd amendment that basically help us to understand what basic structure doctrine is. There are also a lot more cases to deal with when we study about basic structure, but for now we'll stick to these most important landmark judgments that came, and the rest of the cases that need to be studied for the basic structure we'll deal with later. Till then, thank you and have a nice day.